Rollins versus Rollins, case number 1-845-00034. And let me have counsel note your appearances in this case.
Mary Ellen Rollins is here.
I see we have Ms. Rollins. I know Mr. Neely was with us just a moment ago. Is he still available? We don't have any audio. We do have video at Mr. Neely's office, but we have no, I'm not hearing anything.
Okay, just a minute. Don't leave it. Don't.
Take it out.
No.
All right, is Mr. Neely going to be appearing, or is there other counsel going to be handling the matter?
I'm appearing, Your Honor.
All right, thank you, Mr. Neely. We are set to consider the motion to alter or amend that's been filed on behalf of Mr. Rollins. Mr. Neely, I'll hear from you.
Thank you, Your Honor. Your Honor, the court in its findings did indicate that the Marietta, California home was a marital asset in that it was acquired marriage, and you commented that it was sold during the marriage. However, it gets complicated in terms of the sales proceeds. And we submit that the sales proceeds from the sale of the Marietta home are marital assets. The proceeds deposited in this Glacier bank account can be directly traceable to the sale of the Marietta, California home. So we believe that there should be specific findings that the proceeds from the sale of the Marietta home are marital assets. The court did not clearly make a specific finding one way or the other. You didn't rule that the proceeds were separate property. You didn't rule that the proceeds were marital property. And as mentioned, Your Honor, I think it's abundantly clear that the proceeds constituted a marital asset and should be equally divided between the parties. Any marital asset on its face should be equally divided between the parties. In this case,
I do understand that argument, Mr. Neely. Anything else?
Other than she has spent a great deal of the proceeds before the actual trial. The other is alimony. Your Honor, we'd asked for living expense of $1,500 for Mr. Rollins to have a place to rent or live. You indicated that he could sell the 18 acres. Alimony is based on income. It's not based on what property you own. He should not have to be required to sell his 18 acres to pay alimony to Mrs. Rollins, and he shouldn't be required to have to live in his semi-truck for a place to live. And the other is the personal property, personal effects of the parties. We submit we're not divided. You awarded him some things, clothing, coin collection, things like that. But there's a lot of other personal property that was not awarded, for instance, firearms and that type of thing.
All right, thank you, Mr. Neely. Ms. Rollins, do you want to make any statement in connection with the matters today?
Oh, yes. The Marietta house was obtained during the marriage, and it was sold during the marriage, and the assets were spent before the divorce was filed during the marriage. There was no talk of divorce between Mr. Rollins and I at that time. And the living expenses, Mr. Rollins, I understand, has a new job working for Forward Air and making more money than he was making with Sierra England. I turned in exhibits. No, I turned in exhibits that I would like the court to accept because I did not get the final decree of divorce from Mr. Neely I didn't even know a final decree had been submitted to the court and approved and entered. It wasn't until I got the amend notice from Mr. Neely that I questioned why there was an amend when the final decree wasn't done. And I took my response into the court and then found out that the final decree was entered, but Mr. Neely did not supply me with that document. So I would like my exhibits to be entered and admitted into the court today.
All right, in connection with that, this is an argument on the motion to alter or amend. It is not an evidentiary hearing. I'm not hearing evidence today, so I'm not going to consider additional exhibits. And I have I've reviewed the written materials. I'm familiar with the arguments, and of course, I'm familiar with the proceedings themselves. And the parties may very well be aware I reviewed the proposed documents that were submitted very carefully. I made, in fact, several modifications for clarification in the documents that were submitted. They were not simply entered in the form in which they were submitted. And so I am quite familiar with the issues that have been raised and the documents in their present form. Mr. Neely, do you wish to make any brief reply? I'll permit a very brief reply. And I've lost a video connection with Mr. Neely. There was some indication of bandwidth problems. And Mr. Neely, if you can hear me, I will permit a brief reply. I'm not going to require it. Looks like Mr. Neely may be attempting to log back in again. Let's go ahead and just pause the record for a minute. Hopefully Mr. Neely will join us in the next minute or two. So just pause the record and we'll be in brief recess, hopefully until Mr. Neely joins us again. All right, we are back on the record. For whatever reason, Mr. Neely is not back with us. I cannot explain that. And certainly if Mr. Neely rejoins us, I will hear from him. I have heard his argument. I've also considered the written materials that were submitted, and I am going to make some rulings in the case to address the issues that have been raised. This is a motion to alter or amend and requests a modification of the rulings previously made by the court. A motion to alter or amend is appropriate. Is an appropriate procedure. However, it does not provide a basis for reconsideration of the determinations of the court, absent some showing that there is either an evidentiary basis or some other appropriate basis for making a modification. And I'm going to address each of the issues that was raised. The first has to do with the Marietta Home. The court did rule that the Marietta Home had been a marital residence of the parties. However, the court also ruled that that home had been sold during the marriage. Therefore, the home itself was not a marital asset and was not subject to division. It did not exist at the time that the divorce commenced, and therefore was not a part of the marital estate. The question raised or arguments made by Mr. Neely then go to the proceeds from the sale of the marital home. The court did make some findings with respect to that issue and will make some additional consistent findings today. The findings of the court were that the proceeds from the Marietta Home were perhaps used to some extent before the divorce was filed, and to that extent would not be part of the marital estate, and otherwise, based upon the testimony of the parties, were placed in an account which was part of a trust which had been established by the parties. Both parties made reference to the trust. Both parties, and in documentation submitted by the parties, identified the transactions as being transactions from a trust account. The ruling of the court is that a trust is an entity separate from the marital estate, much like a corporation. If the parties own stock in a corporation, the assets of the corporation are not owned by the parties. And so in that analogy, if the parties were owners of a corporation and they each owned 50% of the shares of the corporation, and the corporation owned a home, the home itself is not part of the marital estate. It is part of the corporation's ownership. And therefore, a home owned by a corporation in which the marital partners own stock is not a marital asset because it is owned by a separate entity. In this case, the ruling of the court was that based upon the evidence, the preponderance of the evidence established to the court's determination that these assets were trust assets. Neither party determined, or neither party for whatever reason, provided a copy of the trust to the court, nor did either party provide any evidence to the court of what the duties of the respective trustees may have been, although both of them testified that they at one point exercised certain rights as trustees. To the extent that one claimant in this case, the petitioner, asserts that there were any violation of trust requirements by the respondent, that may be a colorable claim, but that does not constitute or render the trust assets as marital assets. And because the parties did not submit information from which the court could determine a distinction between the trust and any other marital assets, the ruling of the court was that the proceeds were not divisible as marital assets. It is not true to suggest that any asset that any party can identify in a divorce case is necessarily a marital asset. That would suggest that a party could simply come in and say, well, I own the Brooklyn Bridge, and therefore I want the Brooklyn Bridge divided as a marital asset. If the parties do not present evidence that the asset is owned by the parties, then the court does not have a basis on which it can determine that the asset is a marital asset. And in this case, the evidence was that this particular asset at issue, the proceeds from the home, were administered in a trust, and the parties did not submit information regarding the trust. The failure of the parties to submit that evidence does not result in a presumption that trust assets necessarily become marital assets. There is no evidence that they are marital assets, and so the ruling of the court with respect to those assets and any disposition of those assets is not modified. And the court declines to make a ruling that they are marital assets subject to division, or that there was any impropriety in the respondent's use or disposition of those assets at any time. Again, to the extent that that might be an issue based upon some provisions of a trust, which has never been established, that's a different question that is not addressed by the court. The next question has to do with the question of alimony. The objection of the respondent or the request for altering or amending the determination has to do not specifically with the alimony determination, but with respect to the component numbers used for the expenses of the parties. The court, after the trial, declined to award the petitioner a $1,500 allowance to make a house payment. The reason for that is that there was insufficient evidence that he had such an obligation. And absent evidence, the court is not going to authorize an expense that has not been established. The testimony of the petitioner was that he was not paying rent, that he frequently lived in his truck. There was also evidence that a residence had been provided by his employer for which he made no payment. The suggestion that the court from that evidence establish a $1,500 reasonable expense is not sufficiently supported, and the court declines that invitation. To the extent that there is any suggestion that there was any impropriety or any imbalance in the allocation of the real property interest, the recollection of the court and the finding of the court was that each party was awarded a parcel of real estate. Residence property was awarded to the respondent, and that residence property was valued at approximately $400,000 without encumbrance. There was awarded to the petitioner other real estate, non-improved property, also valued at approximately $400,000. And it was the court's determination that that was an appropriate division of the real estate. To the extent that the petitioner is suggesting that he is entitled to have a separate residence beyond the $400,000 real property that was awarded by the court, there is no other property to be divided as far as real estate, and the court declines to award to the petitioner an asset that is not equivalently awarded to the respondent. And so the findings of the court in this case were that the petitioner had failed to present evidence of the reasonableness of the claimed residential expense, and that the evidence of the actual expenses or absence of expenses was addressed by the court. And the court determined that based upon the evidence specifically provided by the petitioner, that it was not appropriate to allow an additional allowance for a house payment under the circumstances of this case. And then, in dividing the real estate, equal interests were divided to each. And each has whatever benefit that flows from those awards of real estate. With respect to the suggestion made more specifically by Mr. Neely, an argument that there should be a further division of personal property, the court declines to make any additional modification to its prior ruling on the basis of the absence of evidence. There simply was not sufficient evidence presented to identify particular items of personal property that should have been divided other than as divided by the court. There were some items that were specifically identified in the evidence. Those items were addressed and divided. The failure of the parties to more specifically identify or request division of particular items cannot be resolved by the courts guessing at what there may be. The obligation was to present the evidence at trial. It was not presented at trial and therefore will not be considered now. As a result, and in summary, the motion to alter or amend is denied. The rulings, findings, and orders which have been entered by the court will remain in place unaltered. So that is the ruling of the court. Mr. Neely, are you back with us? If you're on the phone, I can see what may be an appearance. Mr.
Yes.
Neely, are you with us?
Yes, I am. Can you hear me?
All right. I can hear you, yes. And I don't know what happened with your connection, but because we were unable to make that connection, I have made my ruling in the case. In summary, I'll just provide a very, very brief summary of that ruling, and it is that with respect to the Marietta Home, because the home was sold before the divorce, the home itself was not marital property. And the ruling of the court was that the proceeds from the sale of the home, based upon the evidence presented, were deposited by the parties into a trust and administered within a trust. And there was not evidence that established what the requirements for the administration of assets in the trust may have been. The court further ruled that the trust is a separate legal entity. Its assets are trust assets. The interest of a beneficiary of the trust may very well be any number of things, but there was no evidence presented to the court as to what those interests may have been. And so the ruling of the court is that if a party wants to claim an asset as a marital asset, there must be evidence to establish that claim. There is insufficient evidence to identify the proceeds from the sale of this home as a marital asset. Rather, the court found by a preponderance that it went into a trust, and there was no evidence provided as to its disposition in the trust. Therefore, it is not a marital asset for division in the estate, and the court did not address the matter further, declines to make any modification of its prior ruling. With respect to the claim with respect to the alimony issue, the ruling of the court is that really goes to the request which was made at trial for an allowance for a house payment for the petitioner, which would reduce the available income of the petitioner. The court declined to modify its rulings. That issue was based upon the evidence that was presented largely by the petitioner, which, as the court recalls, included evidence that the respondent was not making a house payment at the time, that he did live substantial periods in his truck, and that at other times he had a residence that was provided at no rental expense to him by an employer. That is the evidence that was presented, and it was on that evidence that the ruling of the court was that the petitioner has not established an entitlement to a house payment. He was awarded real estate, as was the respondent. The value of the real estate awarded to each was roughly equivalent. The appraisals, as the court recalls, on the property were approximately $400,000 for each. Each was awarded equivalent real property. So the court declines to make any modification to its ruling on the division of real property, and also declines to consider the request for a house payment to affect the income of the petitioner. And the ruling of the court is that there is insufficient evidence to support that request. Therefore, that will not be modified. Further, with respect to personal property, the ruling of the court is there is insufficient evidence to make any further division of personal property simply based upon the absence of evidence presented at trial that would justify any such additional determinations. And the absence of evidence precludes the court's readdressing the issue now. The court rules that each of these issues was addressed at the trial. The court rules that they were fully and fairly addressed by the court at the trial, and the rulings, findings, and order of the court will not be modified. So the motion to alter or amend is denied. What I'm going to do is have the clerk prepare a minute entry which the court will sign in this case. That minute entry will indicate that the court has considered the motion together with the arguments and presentations made at the hearing today, and has determined that there is not a proper basis to alter or amend any of the prior rulings or determinations of the court, and that the motion to alter or amend is denied, and the prior rulings of the court remain in full force and effect. So I'm not going to require that either party submit any additional documents with respect to the ruling of the court today. But that is the conclusion of the matter, and based upon that determination, the parties may be excused, and court is adjourned.
So I don't have to prepare an order then, Your Honor. You'll prepare a minute entry.
You do not need to prepare an order. I don't want either party to have to go to any expense to address that matter. I will sign the minute entry and include the language as indicated, and it will also incorporate the actual ruling made on the record. And Mr. Neely, again, for your benefit, I did summarize the ruling after you came back on. There is more to the ruling that was made while apparently you were not able to connect. Certainly you can get a copy of that if you wish to review that with your client.
Okay, I understand.
All right, thank you. Appreciate everyone's appearance today. Stay well, and we are adjourned.